Now, a vitiating factor can make a contract voidable, and unenforceable. What do we mean by void contracts? Void contract means that the contract does not exist from its inception. So you may think that there's a contract, but there's no contract. Voidable means that the contract is valid until someone or one of the parties takes steps to set the contract aside at a court. Now, when you do an unenforceable contract, this contract may be valid, but you cannot enforce it at a court. The court is not interested at whether there was a contract or not. The contract itself cannot be enforced because of the surrounding circumstances or the things involved in, maybe against public policy. Now, what are some of the vitiating factors? We have what you call misrepresentation, mistake, undue influence, duress, illegality, and unconscionability. So basically, this is the introduction. Now, you will start with the various vitiating factors, and we like to start with misrepresentation. Misrepresentation. Now, when you talk about misrepresentation, we are looking at a statement of facts that is false. And this statement is made by one party to another party with the purpose of inducing him or her to enter into a contract, even though that false statement is not part of the terms. Now, misrepresentation makes a contract voidable. I've already explained what you mean by voidable. It means that the contract is valid until someone takes steps to set it aside. Now, such contracts gives the innocent party the right to rescind the contract, i.e., to set aside a contract and even sue for damages. Now, we have indicated or not that misrepresentation is actionable per se. It's actionable. Therefore, there are certain things that you have to satisfy the courts. Now, one, there must be a false statement of fact, not law, as opposed to opinion or estimate of the future. Your statement that you are making is a fact that it is false, but it doesn't based on law. Now, in Bissett v. Wilkinson, the claimant purchased piece of land to use as a sheep farm. He asked the seller how many sheep the land would hold. The seller, who have not used the land for such farm purposes, estimated it to be 2,000 sheep. And the claimant rely on such estimation and purchase the land. It turned out that that statement was false. The claimant sued the defendant for misrepresentation, but he was not successful because the one who made that statement is not into rearing of sheep or didn't have any knowledge as to whether the statement was meant to influence the purchaser. So he only gave opinion. not a statement of facts. Also, a statement of opinion may amount to an actionable misrepresentation where the representative was in a position to know the facts. If you express an opinion and per your position, you should have known that whether or not the opinion that you are going to give is false. Then if it turns out to be false, you will not say that it is the only opinion and you will hold you responsible. If you look at the case of Smith v. Land and House Property Corporation, the Grand Purchase Hotel, the seller described the tenant as being most desirable. Most desirable. It turned out that the tenant was an average bankruptcy. The statement that he was the most desirable was misrepresentation. Or you have known that the tenant is not as such person. A statement as to future intent cannot amount to misrepresentation unless the representative had no intention to carry out the stated intent. So if you make your future intention known, it doesn't amount to misrepresentation. But if it can be deduced that you don't intend to carry that event or action, it will amount to misrepresentation. The case of Edenton v. Fitzmaurice speaks to this particular case. And the claimant purchased some shares in the company. The company prospectus stated that the shares were being offered in order to raise money to expand the company. In fact, the company was experiencing financial difficulties, and the money raised from the sale of the shares was going to be used to pay the company debts. So they did not use the money for the intended purpose. They knew that this money will not be used for the intended purpose, yet they went ahead to influence the people. So the court held them to be liable. But they knew that the money was going to use to pay their debts, but not to increase those shares or expand the business. So that is it. Any question?
Yes, sir.
Yes.
Please, I want to ask a question. Please, my question is, assuming you are building a house and you ask the foreman or the site engineer that how many blocks will it take to build a two-story building, and the contractor or the engineer tells you that, oh, it will be about, let's say, 2,000 blocks, and out of that you also take it that 2,000 blocks will be enough for the construction of the two-story building, and it turned out to be something else, that does mean that it is not it is a misrepresentation.
Take your question again. I didn't get the beginning part.
What I'm trying to say is that assuming you are building a house, and you came to consult me that assuming you are building a house, and you have come to consult me that how many blocks will it take me to build a two-story, and I tell you that it's 2,000 blocks estimation, and out of the estimated blocks you said that then I should take the money to build the house for you, and the blocks were not enough to finish building the house, does it amount to a misrepresentation?
So someone is building, the person contracted you, or the person came to ask whether or not the blocks can fit the building he wants to put across. Is that your case?
Yes, please.
Now, are you an experienced contractor or a mason?
Please, sometimes it do happen. Sometimes it
I
do
asked you a
happen
question. You
that,
have to respond to that question first.
I'm not, but sometimes it do happen that,
So
they will
if
say,
you
oh,
are not,
3,000
then
job.
wait. If you are not, means that you are only expressing an opinion, and that opinion
Uh-huh.
cannot amount to misrepresentation. Look at the
Okay,
first case that
okay.
we discussed.
Uh-huh.
The Bishop B. Wilkinson.
This said
I hope you
versus
get it.
Wilkinson. Yes, please.
Okay. Silence will not generally amount to a representation, a misrepresentation. Your silence will not amount to misrepresentation. So the fact that you have sat or you are quiet does not make you you misrepresent the party. However, there's a case that says that if you go to a restaurant and you receive their bill and you eat, you represent that you can pay. So if you decide not to pay, you are misrepresenting them. In contrast of Obama Fide, one of utmost good faith, such as insurance contracts, that is when insurance people come to you and they ask you questions, you try to hide some of them. So do you fall sick or what is provide information about yourself? How old are you? Instead of you to stay obligation to disclose that change. So you enter into a contract, there is a change in law that will make the whole contract impossible. If you are aware of the change and you don't inform me, it is misrepresentation. Look at the case of Wait v. O'Flanagan. So once it has been established that a false statement has been made, it is then necessary for the misrepresentee to demonstrate that the false statement induce them to enter into a contract. Now, if you are the misrepresentee, the representee or their agent checks out the validity of the statement, it means that they have not relied on that statement. Now, I tell you something and you go and verify, meaning that you are not acting based on my statement, but it's your own independent judgment that you have made small. If the representee is given the opportunity to check out the statement, but does not in fact check it out, reliance must still be demonstrated. Now, you buy, so in the case of Redgrave we had, a solicitor purchased into partnership in the solicitor's firm. He was told the partnership had an income of 300 euros per year and was given the opportunity to look at the account. He declined the offer to check the accounts and took them at their worst. In fact, the income was only 200 per year. It was said that he was entitled to rescind the contract as he relied on the statement. The fact that he had declined the offer to check the book reinforces rather than negates their reliance. So, if you are given opportunity, technically, and you decline, it means that you are on your own. But you still have to demonstrate that you rely on the fourth side statement. If you're able to establish, then so be it. If not, then that is the end. The misrepresentation can be in different forms or types. We have innocent, negligent, and fraudulent. Now, when you take negligent or when you take fraudulent, it has been made that the statement, the one who is making the statement, either knowing it to be false, without belief in its truth, or recklessly carelessly as to whether it is true or false. Look at the case of Derek Bipik. Some of you, sometimes you make false statements, you don't even believe that it is true, and you don't take care to verify whether it is true or false. If such statement influence someone to enter into a contract and turn out to be something different, it means that you have misrepresented the person. A negligent, you also have a negligent misrepresentation. A negligent misrepresentation is a statement made without reasonable ground for believing its truth, and a burden of proof being on the representer to demonstrate that they had reasonable ground for believing the statement to be true. Now, if you are negligent, they are saying that you made that statement without a reasonable ground to be true. But you have a duty to demonstrate that you believe that it was true. We have innocent, as the name suggests. You believe in the truth of the statement, but it turns out to be different. There are remedies for misrepresentation. We have rescission, that to set aside the contracts. So you can rescind the contract by putting the contract aside. When it is fraudulent, you can rescind and claim for damages. When it is negligent, what you can do is that you can rescind the contract and claim for damages. But if it is innocent, you can only sue for damages and continue the contract. So basically, that's what we have under misrepresentation as a initiating factor. I shall pause here for questions.
So please kindly go over again, because when you were speaking, the network was breaking, so I couldn't get it clear.
Is it your network or my network?
It's you're coming from your side.
Hello. Apart from the one who is making complaint that my network, what is my network?
Yes, please.
It's my network.
Sir, I think it's your network, sir.
It was breaking.
So I was saying that for fraudulent misrepresentation, it means that your remedy is that you can set aside a contract. You may decide not to continue with the contract and sue for damages. The same is applicable to negligence. By innocent, you can either rescind or sue for damages. So either you decide not to continue the contract, or you continue and sue for damages. That is what I said. Are you okay now? Hello? Still my network.
It's okay now.
Okay, thank you. Now let's go to what we call mistake. What is mistake? Let me hear from your side. What is mistake? What is mistake?
Damn. Mistake is something that you don't supposed to do and you have done it.
Okay, so that one do mistake. What again? What again?
Please, it's an error which comes involuntarily.
Who else?
Yeah, please, it's an
Sir,
error. Okay, unintentionally.
Point again.
sir, please, an error that happens in the process of doing something.
So you have made a lot of definition for mistake. Winifred, you have a question?
Sir, I wanted to contribute, but it's okay, sir.
Okay. I Winifred, rather sorry. I didn't say I thought Winifred. Sorry. Winifred.
Okay.
Now, when you talk about mistake in law, it has definition different from what you people know. Mistake in law has been grouped into three: common mistake, mutual mistake, unilateral mistake. So it depends on where you are talking about it. Now, common mistake, both parties make the same mistake. Mutual mistake, one party or the parties are at cross purpose. Unilateral mistake, only one party is mistaken. So you will see some of the examples when you talk about mistake in contracts. Now, when the court makes a finding of mistake, it will render the contract void, meaning that the contract doesn't exist. Now, when the contract is voidable, the contract exists. You have explained these things. Let's look at common mistake. We have indicated that here both parties make the same mistake. And these are some of the mistakes. The first one is known as res extincta. Res extincta. For instance, Kofi and Ama has entered into a contract. Kofi is selling his car to Ama. They have agreed on the price they have paid. But unknown to both of them, the car has been stolen. There is no contract. That is what you call res extincta. You also have what you call res swap. Res swap simply means that the purchaser already owns the item that he has bought. For instance, your father has a lot of mansions. You just came back from UK and you wanted to surprise your dad, and therefore you have bought a house in Ghana. Unknown to you, your father has already registered the house in your name. So the one who sold the house to you, between you and that person, there is no contract. That's what we call res swap. Res swap. Mistake as to quality. Mistake as to quality. So if the quality that you are looking for is not the same as what you have been given, so there's a mistake. And mistake as to quality is only capable of rendering a contract void if the mistake is as to the existence of some quality where the subject matter of the contract essentially different from that which it was believed to be so. So if it turns out that the quality that you are looking for. Without that quality, the thing doesn't stand. There's a mistake. So these are the various types of common mistake. Now let's look at mutual mistake. Mutual, both parties at cross purpose. And of course, we apply the objective test to know whether or not there was an agreement. The popular case that comes to mind is Raphael v. Wakehurst. Here, the complainant, Mr. Raphael, offered to sell an amount of suet cotton to defendant, Mr. Wakehurst. This suet cotton would be brought to Liverpool by a ship from Bombay, India. This ship was called Palace, but there were two ships that had this name. So the item will be coming from Bombay in India with the ship named Palace or Peerless, but there were two Peerless ships. One was to come to Bombay in October, and one was to come in December. The sugar cotton arrived in Liverpool when Mr. Wakehurst refused to pay, as in his mind it was the month late. So whilst they were expecting it in October, they brought it December. So in his mind, they are delayed. So the court heard that the contract between the complainant and defendant was not enforceable because they were all at cross purpose. They are all thinking about something different. So that is the import of this aspect. Now, unilateral mistake, one party is making the mistake, another party is aware of it. So for this to be operative, the seller needed to know the buyer was mistaken as to the terms of the offer. So as I said, the other party is aware, but he says nothing. So that is a mistake as to the terms. Now read the case of Hatton v. Collins and Smith v. Hughes. Mistakes to identity. So in this type of contract, we have two types. Contract inter absentee, which means that you are not there. Contract inter presentee, face to face. So the rule is that where the parties are not physically present, when the contract is made, for instance, when you make a contract through telephone, post, or internet, the court will only make a finding on mistake if the claimant can demonstrate an identifiable person or business with whom he intended to deal with. So look at the case of Candy v. Lindsay, where a rogue Brancan hired room at 37 Road Street, Cheapside. This was in the same street that a highly reputable firm called Brancan and Sons traded. The rogue ordered a quantity of handkerchiefs from claimant disguising the signature of to appear as Brancan. The goods were sold. The goods were dispatched to Brancan and Co. 37 Wood Street, but payment failed. Brancan sold quantity of the handkerchief to unto defendants who purchased them in good faith and sold them in the course of their trade. The claimant brought an action based in the thought of convention to recover the value of the handkerchief, The success of the action depends on whether the contract between banker and the claimant being void. So here, what the court is saying is that you can make a case that the contract that you enter with someone on the internet is void because the person at the other end knew that he was not the person you intended to deal with. And therefore, such contract is void. Contrast your case with King Nothing Matters Company. Contract interpretation. That is face-to-face transaction. The law is that when someone is before you and you enter into a contract, the presumption is that you are dealing with the person before you. So if I appear before you and I say you I'm sure and show me why I'm not, and you deal with me, the law is that I am the person I claim to be. Some case law says that no. If it turns out that you are not the same person, you can be sued. So that is the principle. Now you have what we call mistake in relation to execution of a document. Please let me ask you, if you go to bank and they give you document that's signed, you read all of them?
No, sir.
No, sir.
Anyone which responds. Now, what this means is that.
So if you responded,
yeah, I know two people have responded, but I want another person. What it means is that
no, please.
Once you have signed, it means that you have read all the things in the document and you believe it to be true. Therefore, you cannot deny that that was not your deed. Not as fatum. However, you can make a plea that what you sign is not what you intended to sign. You require non ex fatum as a defense. Now, to prove or to be successful for us on the defense of non ex fatum as mistake, you have to prove that there has been a mistake, and the one who made a mistake was misled in making the mistake. And the mistake related to document radically different from what one thought he signed. The one signing seeking to rely on the plea should not be guilty of negligence or careless. So when they give you document, sign here, and you are signing, and you don't read, it will bind you, and you can't raise the defense of non-ex fatum. I want someone to read the case of Foster v. McKinnon. Who will do that for us? Let me mention names. Francesca.
Sir.
Read the case for us.
Sir, please, you said Foster and then, sir, please mention that name for me. McKinnon. No, the name, is it McKinnon or? McKinnon. So in Foster versus McKinnon, 1869, the defendant, a Snellman with poor eyesight, was induced to sign a document which was told was a guarantee. In fact, it was a bill of exchange upon which the exclaimant and time ultimately became entitled. It was held that the defendant, who had not been negligent, was not liable on the bill, the plea of non-est
fatum.
Non-est fatum succeeded.
Who said come and do law? I don't understand who registered. So you understand the principle. So someone has poor eyesight, and you have induced him to sign a document different from what he intended to sign. The court can say no, the person was not negligent. So the plea will hold. But with the case of Sanders v. Anglia Building Society, the same Franca.
A.
Why A?
However, in Sanders versus Anglia Building Society, okay, an elderly widow wishes to transfer the title of a house to her nephew by way of gift. Her nephew and a man named Lee prepared a document assigning the property to Lee and asked her to sign. She signed it and read, as she had lost her spectacles and trusted her nephew. Lee mortgaged the property to the building society and disposed of the money raised for his own use. He defaulted on the repayments, and the building society sought possession of the house. Sanders, the widow's executrix, sought a declaration that the assignment to Lee was void by reason of non-ex fatum.
So they saw declaration that the assignment to the Lee was void by reason of non-ex fatum. If you read the full case, so they have not given you the judgment yet too. So read this side. Continue with this side. In view of the court, yes.
In the view of both the Court of Appeal and the House of Lords, the plea could not be raised because, one, the transaction the widow had entered was not fundamentally different from what she intended at the time she entered it. And two, she had been careless in signing the document. She could at least have made sure that the transfer was to the person intended by her.
So you have not noticed the difference between the first case. The first case, the person was not negligent, poor eyesight. But the second one, the person never used glasses, and at that point he failed to use that one, so he couldn't read. Because he has lost his spectacle. But I'm taking steps to ensure that he get new one before signing. So those who will be signing documents and you don't check, don't come and raise non-ex fatum. That this is not my deed. So when we say non-ex fatum, what you are saying that this is not my deed. This is not what you intended to sign. And there are guiding principles. So note that. I hope you understand. Please, you understand? Hello?
Yes, sir.
Okay, thank you. Let's look at undue influence. Undue influence is also one of the processes or one of the vitiating factors. So when you talk about undue influence, you are saying that it's also an equitable remedy which involves one person taking undue advantage over the other. So in the case of Mercer v. Brimpon, the court explained undue influence as any means by which the exercise of free will or deliberate judgment is excluded at a time when the interest or benefits is given to another person by someone over whom such influence was exercised. So if you pass rights at a time that you were unduly influenced, then that transaction is tainted by undue influence. But there are different types. We have presumed undue influence and actual undue influence. Undue, the presumed is based on operation of law, like teacher, students. You know, if I'm buying something from you, you may decide to give me at a very cheap price because you know, or you'll be thinking that if you fail, or if you fail to sell me at that, I will intentionally fail you. Child and parents, if you know you don't do, your parents can do something to you. Government and citizens, government may decide to bring you high taxes. Religious body leaders and church members. If your pastor is buying something for you and you treat him like you are treating any ordinary person, you know. So under these circumstances, the law presumes that there is undue influence. So you also have actual undue influence. There's no presumption of undue influence, but the evidence is clear. You are signing a contract with a mental, someone who has mental problem or someone who is of age. You know that two of you, someone is inducing his friend. So undue influence makes a contract voidable. And the contract will not stand until someone takes steps to set it aside. So the effect of undue influence is that it's made a contract voidable, meaning the contract will not stand until someone takes steps to set it aside. Any question for undue influence before you go to the rest? Any question? So if there's no question, let's look at duress. Duress is when you use force or you threaten someone to sell his product to you or enter into a contract with you. Now, a contract can be set aside because of threats. You are required to establish that there was actual physical violence to or unlawful constraint the person of the contracting party. So yeah, you were threatened. In Human v. Kofi, the court held that there must be coercion of will. You have to be forced. For instance, if someone says that before your uncle or your brother is here, if you don't sell me your property at this place, they will not release him. That's why you are under duress and you will make an attempt to what? Sell. Now, if you look at Human v. Kofi, here, Kofi was detained by the police for 8 weeks as part of a debt collection exercise. Earlier, police had detained his son for 4 days because they could not locate him. Police said that they would only release him if he sold his house and paid off the debt. Kofi agreed, and the police found a buyer, Ms. Emmons. After selling the house, Kofi brought an action to set aside the sale. So you police, instead of you to do a good work, you have agreed to that before you release the person, and let the person sell the house to someone. And you are going ahead to find your own buyer. You know the connection between the buyer and the other man, the police officer, precisely. And of course, the present position, therefore, is that to be capable of giving rise to duress, the threat must be illegitimate, not reasonable, because what is threatened is legally wrong, or because the threat itself is wrongful, or because it is contrary to public policy. So that is it. Now, duress also makes contract voidable. I'll pause here and take few questions before I deal with the last vitiating factor. Please, any question? Please, any question?
Someone has raised his hand.
No question, let's proceed. We have public policy and illegality. Public policy is difficult to define, but anything that is against the norms of the society, it means that it's against public policy. Now, illegal contract makes the contract invalid or void at what ab initio. Illegal contracts can take form in different ways. So when it infringes on statute or precedents. Now, an illegal contract may be one, the terms of which it infringes on provision of statute or precedent. So if you enter into a contract that breaches a law, that contract is invalid. You take someone's money, or you enter into a contract for someone to go and beat another people. Beating is a crime, and therefore, when you enter into a contract for someone to go and beat another person, it is illegal. In Olatibu versus Captain, it was said that the court will not assist a plaintiff to recover an illegal contract. So when you enter into an illegal contract and the person fails to pay you, you can't go. If you go to court, but your case should be dismissed. A contract may be perfectly legal, but the purpose to which the subject matter would be used is illegal. So the contract itself is legal, but the purpose is not. For instance, the case of Lantin v. Hughes. The case of Lantin v. Hughes. The plaintiff sold to the defendant a brewer, Spanish juice, isinglass, and ginger. He was aware that the intent was to use this substance in a beer contrary to a statute, which made it offense to flavor beer with anything but malt and hops. It was said that the contract was illegal and the claimant could not recover anything because he was aware that the product was going to be used for an illegal purpose. So the contract may be good or valid or legal, but the purpose can make it illegal. A contract that seeks to indemnify a party against deliberate commission of a crime would not be enforced. So sometimes people hire people to go and kill someone. If after killing you don't receive your money, you cannot bring it to court. Now we have said that public policy is difficult to define, and anything that is against the norms and on the society that is not in favor of the public or it is not good for the public consumption is against public policy. Some of these things include: 1, agreement to injure the public service. Any agreement that tends to the corruption of private citizens. Agreement that perverts, obstructs public justice. You take bribe, you give judge bribe. You agree to encourage litigation, immoral decency, gambling transactions. Agreements induce fraud and breach of trust. Unreasonable trade restraint. All these are against public policy, and therefore the court will not enforce such contracts. The next point I want to talk about it is what we call unconscionability. Unconscionable. Unconscionable means that no reasonable person will do in his right senses will do that. And a contract which is unconscionable will not be enforced by a court. Now, if you are looking at unconscionable contracts, we are saying that that contract is unjust. That contract is one-sided. That contract is too harsh on the other party. So, example include when a party that typically engage in sophisticated business transaction insert language into a contract containing terms unlikely to be understood or appreciated by the average person, such as a disclaimer or warranties, or provision extending liability for a newly purchased item to goods previously purchased from the same seller. Such contract is unconscionable. When the seller also inflates the price of the goods, but when this inflation is conducted in a way that conceals the buyer the total cost for which the buyer will ultimately be liable. So those who inflate price abnormally, that is your case. Where a seller offers a standardized contract for the purchase of necessary goods or service. So for instance, food, shelter, means of transport to consumer on take or leave it basis, without giving the consumer realistic opportunity to negotiate terms that will benefit, that contract is unconscionable. So basically, these are the various vitiating factors that we were trying to discuss this afternoon. Any question? Any question or any concern?
Sir, concern, sir.
Yes.
Sir, so from unit 1 to unit 3, there are a lot of cases. So and so verse this, so and so verse that. Sir, so how will you know, in case there is a case, how will you know that this case is in relation to this particular topic? Maybe in section 1, section 2. Sir, there are a lot of cases. I don't know which one to go for. Thank you, sir.
The law is the law. No matter what you do, the law is the law. Why are you laughing? You'll be fine.
Sir, we just need a clue that, oh, when you see this particular case.
So when you are studying, when you read the topic comes with its case. So the principle that you read, you know there's a case to it. So that case tells you that this is where I am. You get it? So for instance, hello, for instance, if you are talking about undue influence, Mercer be Bimpon, we talk about it. So you know Mercer be Bimpon is under undue influence, and it explains what undue influence is. Karen versus Catholic Snowball, we talk about issues of unilateral contracts. So when you study them, you study your notes one by one, and you master them where they are, you know. It's a gradual process. You get it? It's gradual process.
Sir, please, like we are saying, it's a gradual process. But looking at the quantum of the cases that you have to defend with a question, that is where we are also looking at. Because we've seen so many cases with relevant.
And you continue to see them till you finish this course.
Hey, with this one, the kingdom come.
That makes the law the law. That makes the law difficult. So that is it. But try and read and learn it small, you'll be fine. Okay?
Yes, please, sir. We will try our best.
Okay. If there's no other question, we will bring the class to an end. Are you meeting next week?
Revision week, sir.
No, sir. We will meet you on 7th July, sir.
Yes.
We meet you on
Sir, Saba,
I'm listening, please.
Saba, like when you have time, we can join so that we can do some past questions.
I thought about me having time.
Yes, sir.
Sir, please, I wish we can use we can pick a day within the course of the week, maybe Thursday, so that you can have an overview of the whole unit 1 to unit 3 for us, so that we'll be able to understand some of the things very well.
No, today if I'm done, I'm done.
Sir, I personally wish we can go just a snapshot of what we've gone through, like in the form of a revision, maybe about an hour.
Have you read? Wait. When we start, have you read your notes?
Yes, please. I've been reading small, but you know, some of us are working. So
do it small.
Quite difficult for us.
Okay, do it small. You'll be fine.
Yes, please.
Okay, thank you very much.
The law is the law.
Francisca, I said, show
The law is the law.
The law is the law.
Sir,
show your face.
any past question for us?
In fact, wait, you are coming to do roll call.
Francisca, show your face. Francisca, show your face.
Francisca, wait, show your face. After Francisca, Francis Esando.
Sir.
Yes.
Hello, sir.
Yes, where is your face? After Francis Esando, Rebecca.
Sir, please, any past questions for us?
I'm asking what you are talking about past questions. Francis Esando. Where are you?
I'm here.
Sir, I'm here.
Let me see. Francis.
Yeah.
Yes. Wait. You didn't show your face. Francisca, you didn't show your face.
Sir, please, I'm showing my face.
Okay. Me too, my face is here.
Wow.
The law is the law.
The law. Yes.
Sir, I'm here, Francis.
Moses, show your face. In fact, if you don't show your face, when I see you, I'll just bypass you.
Sir, I didn't see your face.
No, sir.
Me, my screen is still on. The next person.
Francis
The
also.
law is the law.
The law is the
Okay,
law.
Moses.
The law says show your face. You have to abide to
The
it.
one who asked for tutorials, where are you?
Sir, please, I'm here.
Show your face.
Sir, yeah, my.
Enoch.
Yes, sir.
Yo. Charlotte.
The law is the law.
Sir, please, Apo.
Rebecca, show your face.
Rebecca, you like a phone.
Rebecca, she show her face. She's saying Apo.
Rebecca.
Sir.
Show your face.
Sir, I'm here.
Okay. Daniel.
Sir.
Okay. MFA. Emmanuel. Ernestina. The rest, if you don't mention your name, that is the end.
Sir.
Sir, David.
And I say, where are you?
Sir,
Yeah, sir.
you didn't mention my name.
Okay.
Mario David.
Sir, I'm
So,
here,
You didn't
Linda.
mention my name.
if you had mentioned, show your face.
Sir, please, this is Linda.
Mario,
Okay, Linda, I've seen you.
this is David.
So thank you for your time. Prepare well for the exams. I wish you all the best.
Thank you, sir.
Thank you, sir. Thank you, sir. God bless
Your
you.
groups, start forming your groups for the presentation. Enjoy the rest
Yes,
of
sir.
your day.
Same to you,
Sir, please,
sir.
someone takes that for. Someone takes that for.
No one has a poll.
Oh, sir, Sister Ernestina asks of our Paul. Please give it to us.
Thou shalt not give a poll in the Bible.
Okay, sir. What are we expecting the exam?
Read everything.
Sir, what are we expecting the exam?
Read all things. So,
Sir, areas.
Lord doesn't have areas. So,
The law is the law. Let's go and learn.
yes.
Mm-hmm.
So, see you after the quiz. Bye bye.
Yes, sir.
The law is the law. The law is the law. In Enoch versus Francisca, you will learn plenty.
You see that? Come again, you said what?
I said in Enoch versus Francisca, you get to know a lot of things. So the law is the law.
Oh my.
Francisca, you are my sister. I have to know you. You understand?
Oh, sure. We are all brothers and sisters.
Which center are you?
Oh. Yes, please.
Okay. I'm in that class.
Oh, okay. Mohammed.
Oh, Francis, is it far?
Mohammed, show your face. Yes, it's far. It's far. It's far from your end.
Francisca, I've been coming to Afro, so you the next time I come to Afro, I'll try to look for you.
No problem. But I'm in
After we are far from home.
Yes. I'm not in Ho, but my center is Ho. I'm from Adidome.
Francisca, I'll come and look for you.
Okay.
I'll slap you.
I am in Abo.
Hey, Francisca.
I'm in Abo.
Say, you are Abo?
Yeah, Abo.
Oh, okay.
I'll be passing Sogakopo. So when I alight at Sogakopo, I'll just take Adidome and come.
Oh, okay.
You take a year, I'm a gadget. Okay.
Mohammed, did you show your face?
When I come to campus, I'll see what I'll do.
I didn't see.
Oh, maybe I
didn't see your face.
For Francis, they have seen their face. I think I call it too. The name I call it, yes.
I didn't see your face.
Who? My face?
Yes, your face. I didn't see it.
Oh, I showed my face before.
No, I didn't see it. My network was.
Okay, this is my face.
Oh,
People. I call it show your face. Mohammed, show your face.
Oh, me today where I am, I can't show my face.
You can't show your face, eh? Okay.
That's why I leave the class. So I'm not even following the class today.
Okay, you can't show your face, but you can go to Abo.
Sister Charlotte, please show your face.
Today the whole day I didn't join the class well. I didn't the whole day since morning.
Panika, Halawi, you have to give us your number so that we'll check up on you.
Yeah, when you contact Mohammed, no, he will give you my number.
I don't know Mohammed. Hey.
Mohammed is there. He's responding.
What is it?
Mohammed, they say you are the intermediary, so
yes.
You give us your number.
Okay, please, guys, have a nice day.
Yeah, you too, you too.
Chai Francis.
Yeah, okay.
I beg you, when you guys go come for you guys go count the center. Meet the whole
Yeah,
the quantity and the
I know.
quantitative. I
I
didn't
had to.
join.
I had so I already feel up.
Ah, oh, sorry.
So yeah, if I make fine, I will come. Yeah.
Oh, sorry.
And they praise
So
me
how you
by
go
next
count?
week, yeah.
How you go count like the exam?
And that's why they praise me by next week, yeah. Now I make fine.
Oh. So how is it now?
So we did. I did fine. I did fine.
Thank God. Thank God. Thank God.
Yeah. You know,
I dey go
better
work
time,
for
right?
somebody. I dey go
Oh,
work
okay,
for somebody.
okay.
At this site.
Oh, okay. Charlie, take care.
All right. All right.
Oh, you know, nice. I took what? Go.
Okay.